counsel. Each of you will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. And if you would let me know, that would be appreciated if you would like to reserve those minutes. Thank you.
Thank you, Your Honors. May it please the Court, I would like to reserve 4 minutes for rebuttal.
Thank you.
Your Honors, I am Attorney Kristen Kowalski, and today I'm representing Deandra Thomas in the pending appeal. I've submitted my brief, and I would like to make a few arguments regarding that brief. I'd like to focus on the first 2 assignments of error on behalf of the appellant. The first assignment of error was our objection or our appeal of the court's decision to allow evidence of the defendant's statement or appellant's statement in regard to being at the co-defendant's house for the purpose of purchasing drugs. It's our position that that was not necessary to be admitted. It was not relevant to the pending action or any of the charges. In fact, Mr. Thomas had made statements that would preclude any necessary reason to include that statement for any purpose that might be admissible, such as motive, opportunity, intent, preparation, plan, knowledge, identity or absence of mistake or accident. Mr. Thomas did admit during the course of his statement to the detective that he was present at Mr. Person's house, and allowing the additional facts into evidence that he was there to purchase drugs only went for the impermissible purpose of character.
Well, you know, I really agree. I wondered how that really benefits the state from the perspective of having him admit that he was there to purchase drugs. How does that make it more likely than not that he would engage in some kind of sexual attack?
Well, it goes to, like I said, character. It places within the jurors' minds doubt about his I guess, propensity for committing illegal acts, or it goes to their perhaps perception of his credibility. This is a case that it's imperative because we have it's basically one person's statement against another, and it's very we need to be extremely careful in a situation like this to make sure that we're not putting the defendant or an appellant in a position where his credibility is being attacked in an impermissible way.
So you would agree with me that there's a difference between, let's assume that he made a statement to the police that he had a prior conviction for rape. You would agree with me that that would be more damaging because of the relationship between what he is being accused of doing in this case. That would be more damaging than I was there to purchase drugs.
I mean, it could be. It depends on what's in the mind of the jurors. I mean, illegal acts are illegal acts. And I think that, you know, it's sort of a case-by-case basis, but I think any allusion to other criminal acts during a trial, especially if there's no real good reason to include them in the testimony because we already have every permissible purpose already available to the state to use in that with the rest of the testimony, with the rest of the, well, actually it wasn't testimony, it was a statement to the detective. They could establish every permissible reason that they had to use that without including this information.
Well, doesn't it really, in essence, didn't really, in essence, help the defendant here in the respect that this is such a bizarre thing, you know, what happened here supposedly. And he's painting the picture that he's there just to get some drugs. So this bad guy, who's the drug dealer, is beating and raping this woman. And he has nothing involved there. All he's there for is to get some drugs. So doesn't that kind of, I mean, it may paint him in front of the jury as an addict or, you know, user or whatever you want to say, but it almost, in a way, doesn't it really help him to say, I have a purpose for being here. It's not to have any involvement with this woman. I have nothing to do with this. I'm just here to get some drugs. How do you explain being there and saying there?
Well, defense counsel objected to the admission of this. We don't know how, whether, you know, what the effect potential was on the jurors. Mm-hmm. But there certainly is a potential that it was harmful to their perception of him.
And what was the basis of that objection?
The basis of the objection to the admission of the statement was, I believe that was just that it wasn't, it was more, the probative value was substantially weighed by the danger of prejudice.
But that was just for the whole statement.
That was for the, I believe the particular references to the reason that he was there for the purpose of.
But this came in through his statement.
Right, it was a statement that he made to the detective. I also wanted to touch on the second assignment of error, wherein appellant is arguing that the testimony of the same nurse was impermissibly admitted to the extent that it addressed statements by the alleged victim to the nurse because it was hearsay and that it should have been excluded for those reasons. I did reference the State versus Stahl case because that is the case that gives us the most comment by the Supreme Court on the issue of, you know, this same nurse testimony, whether or not it's admissible. Now I know that that case addresses a situation where the declarant was not available, and in this case the declarant did testify, but I think that that's even a greater reason why this should have been excluded in this case, because we're not trying to protect her ability to, or the state's ability to use a statement like that. They have the alleged victim to come in and make that statement. So I did do an analysis a little bit under Stahl because you know, that's where the court is trying to determine whether it's testimonial or non-testimonial. And I did distinguish this case from Stahl as far as the facts were concerned, other than the fact that the declarant was unavailable in Stahl.
In a way, though, wouldn't this even benefit the defendant even more because for impeachment purposes? I mean, if anything that she testified to didn't comport with what she testified, what the nurse's statements were at the hospital, the defendant could undermine the defendant's, I mean, the victim's statements at trial. We benefit him in that sense as well.
Well, I think that's a possibility, but I think there's also the danger that you're bolstering the witnesses, the potential victim's statement by just repetition and no ability to cross-examine on that first time that it's put out there. I mean, the defense is in a position where the jury is hearing all of these things that she said without being able to then step up and, do its job in cross-examining that to undermine what she's said, so that the jury can understand, maybe what is closer to the truth. So then we have two statements from, it's basically allowing the alleged victim to testify twice. So, and the statements that she made, that the same nurse in this case made, were not for the purposes of medical treatment, because they were statements, at least not all of them, they were statements that were made regarding, who said what to her and things of that nature, where, those are clearly not for medical purposes. Those are for the purpose of, just to make some testimonial or statements for the prosecution.
And you're nearing into your 4 minutes if you'd like to reserve that.
I would thank you.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Thomas's convictions in this case. With regard to the first assignment of error, with regard to, I guess I'll start with the sane nurse, the second assignment of error. That case, Stahl has held that we can introduce the sane nurse's testimony because it is not testimonial. While I can understand defense counsel's position that any statement to the sane nurse beyond what would, in their opinion, be medical should be considered testimonial, that's not what the courts have held. The nurse testified that the history is part of what they need to do to conduct an examination, and the courts have held that history is part of the examination, therefore it's part of the medical purposes, and it's not testimonial. So there have been a number of cases, including the Ohio Supreme Court, that have held that way. There's nothing in this case to distinguish it from the situation in Stahl. It was not objected to as a Sixth Amendment confrontation issue. It was raised as a 403 issue, so that hasn't even been preserved on appeal. So the state would ask the court to follow the Supreme Court's case law on this and find that the sane nurse's testimony was properly admitted as non-testimonial and affirm on that basis. With regard to the testimony about Mr. Thomas stating to the police that he went there for drugs, first off, I would agree with Judge Carr that the fact pattern in this case is very unusual. Mr. Thomas initially took the position that he wasn't there, he had no involvement. Then he tried to say that he was there, but he went there for drugs. And then once he got there, under duress by Mike Person, that he engaged in sexual conduct with Miss Moss, but it was under duress. So the statement that he went there for drugs helps, it can help bolster his whole opinion that his whole statement that he wasn't there for any reason. So I don't think if there was any error, if it was anything other than harmless. But it does help the state show that he was giving a story to establish why he was there, to show that first of all, he had no involvement, he just went there for his drugs. Then it was, I went there for drugs, but I was forced to engage in sexual conduct against my will. So it is relevant to help the jury see Mr. Thomas's credibility as far as the different versions of the story that he gave, and then the story that Miss Moss gave. And her story was that, she was there, and Mr. Person had been her boyfriend and had gotten more aggressive, and that day had physically assaulted her and, you know, basically told Mr. Thomas to engage in oral and vaginal sex with her, and that Mr. Thomas did so, and at no point while that was occurring was Mr. Person exerting any type of duress or threats on Mr. Thomas. In other words, it went against his contention that he only did it because he was afraid that Mr. Person would kill him. So that's why that was relevant, and it goes, you know, to the credibility of Ms. Moss as well as Mr. Thomas, and that was something for the jury to consider when they looked at this fact pattern. What Mr. Thomas, eventually, his story was that he got there and Ms. Moss was half naked, and Mr. Person basically told him to, you know, he'll get to him when he gets to him, but in the meantime, you know, go ahead and have sex with Ms. Moss, and that was his version of events. So it was relevant as to establish credibility and to undermine Mr. Thomas's theory of the case, which was that he either never went there for at all, that he did go there for drugs, and or that he went there for drugs and then was forced into engaging in this sexual activity against his will. So there is no evidence of duress. In fact, at one point, Mr. Person left the room, and instead of ceasing the activity, Ms. Moss testified that Mr. Thomas continued, and that you know, at no point offered to help her, at no point, you know, called 911, at no point did anything other than, you know, engage in these sexual activities, and also punched her in the eye to the extent that she had vision issues that were still existing at the time of trial. Mr. Thomas testified that he just kind of mugged her, was the phrase that he used, and that he wasn't causing her any harm. It was part of the duress, but that was countered by the victim's testimony. If there are no questions from the court, I would rest on brief. Thank you, Your Honor.
You do have your 4 minutes.
Thank you. I would just briefly like to address the issue of duress. I think that Mr. Thomas made many statements that suggested that he was under duress, and I referenced them in my brief. And to give the court a little bit of an idea of some of the things that he said, he agrees on 38 and 39 that he was fearful of Michael Person. At one point, on page 97, he said he looked like a gorilla on a rampage. He often references their size differential, that he's 135 pounds soaking wet, and asks the detective, have you seen Mr. Person? There are elements that he was under duress because the detective asks him, you know, why didn't you fight back? And he, of course, his response is, have you seen him? He was fearful of him. When he was asked, you know, why were you engaging this? He's pretty consistent in saying that he didn't want to. In fact, he is consistent in saying he didn't want to, and that and many times he's saying he was afraid. He was trying to sort of keep the peace and try to get out safely. So I do think that there was significant evidence of duress in this case.
He acknowledged that he did not make any attempts when Mr. Person was not in the room to provide any assistance to the victim, or to, you know, try to help her escape. And in fact, didn't he admit to punching her?
No, I don't believe he ever admitted to punching her. I think what the phrase was, he mugged her, was what he said, and the way he described it, he sort of, from what I understand from his description, was that he sort of pushed her head, which was different than punching. There were many times in in the statements where, the testimony with the alleged victim, that she was saying that Mr. Person was hitting her repeatedly in the face. So where those injuries came from, given the discrepancy. But that aside, to go back to the same nurse testimony just briefly, this case is distinguishable by Stahl. Stahl does not make it an absolute certainty that the statements made to a sane nurse should be admitted as non-testimonial, and it does give us a test. And if the test is whether an objective person would have concluded the statement would be later used in prosecution, under the facts of Stahl, they're a lot different. In Stahl, the alleged victim made an extensive statement to police before she went to the hospital. She only repeated what she had said to police at the hospital with the officer present. So it's easier to see in that case how, by repeating the statement to the nurse, the officer already knew. She was only repeating it for the purposes of for medical treatment. They already knew that. Here, she's at the hospital. She makes a very brief statement. The officers say, we're going to talk to you later. We're going to follow you, or we're going to go over and meet you over at St. Thomas.
And you're out of time.
I'm sorry.
That's okay. Fine. You just need to interrupt.
Okay.
All right.
And so, based on the arguments of the brief, that's what you do.
Thank you. Thank you very much. The court will take the matter under advisement and issue a written opinion that will be sent to both of you. And you can look on the websites as well.
Thank you.